Good evening. I'm attorney Lawrence Berliner. I'm an attorney in the field of special education law. My office is located in Westport, Connecticut. Our co-host tonight and every webinar is Jane Faherty, who is an advocate and the director of the Stamford JCC JumpStart program. We are fortunate to have again Allie Grafman, who's an advocate. We'll get to Allie in a moment. Jane and I are continuing to present our Zoom webinars. We are part of a community of concerned parents, professionals. And after we've been doing this for, 6 years now, we've decided we're still continuing to learn how to connect with one another. For the past school years, we've been moderating a series of webinars to address unprecedented times, the need to address social, emotional, educational impact upon children with disabilities. Their educational journey couldn't be greater. We are here to try to empower parents for the road ahead and discuss what's on your mind. We have many questions that came in before the webinar started. If you are asking questions during the webinar, we ask that you put the questions in the Q&A feature at the bottom of your computer screen rather than the chat. The reason is this webinar is being recorded. What's in Q&A is not part of the recording, whereas what's in chat is. Our special guest is Allie Grafman, who's a special education advocate, ABC Advocacy LLC. She's a frequent contributor to these webinars, and we very much appreciate her perspective. And we'll be going over assessing a child's progress. We talk about basic educational rights, the importance of parent input in developing IEPs and contributing to this year and the coming years, because you see your child in multiple settings, whereas school staff typically see a child in only one setting, the school district. We're at the end of the school year. Many of you are having annual review PPT meetings or IEP meetings in other states, and you want to plan ahead for the 26-27 school year. I have a disclaimer. The webinar is being recorded, as I mentioned before. A copy of the webinar will be posted to YouTube. If you've signed up for the webinar, you'll have access to a copy. The information in this webinar does not constitute specific legal, educational, or professional advice regarding you or your child, and should not be relied upon as such. The webinar does not establish an attorney-client relationship with attorney Lawrence Berliner, a professional relationship with Jane Faherty, the JumpStart program, the Stamford JCC, or Allie Grafman from ABC Advocacy. The information provided during the webinar is based upon Connecticut state law, policies, and federal or United States law. If you're watching this webinar from another state or country, and we do welcome those who are coming to us from, as I say, across the pond, you should consult your local jurisdiction to find out what laws and policies are in effect. Third-party recording of this webinar is not allowed, nor can the contents of this webinar be used in any manner for the purpose of training artificial intelligence, technologies, or systems without the express written consent of myself, attorney Lawrence Berliner, Jane Faherty, and Allie Grafman. So without further ado, we can start our webinar. Jane, what's new?
Hi, good evening, Larry and Allie. Yes, so we've been doing this for over 6 years now, Larry, and each year we keep thinking that there's going to be a turning point in the universe, but alas, we still have some challenges to contend with, and this typically is a very busy and at times a difficult time of year for parents when they reconcile how far their the progress the child has made and the progress they are yet to make as they plan and prepare for the year ahead. So we're really looking forward to having this conversation this evening. I'm also, as well as being an advocate, a private advocate, I also oversee program at the Stamford JCC for toddlers with developmental disabilities and delays. And Stamford, and also we have a classroom in Norwalk, and we have a summer camp program called Hand in Hand, which is going to be in full swing in about a month's time. So a lot going on, but enjoyable time of year nonetheless. And it's nice that the sun has started to shine for us too. So Ali, it's lovely to have you back here again this evening and to join in the conversation.
Thank you. Just a quick introduction. I'm Allie Grafman. I have been doing advocacy for the past, I guess it's 12 years now. My former professional life has always been as an adult educator in the field of special education, and I also have been a special education administrator. With that perspective, I feel that my background and my expertise is really about supporting parents and families and guardians to help and support them navigating the school districts and resources that are needed for their child. I love what I do. I feel that I am grateful for the opportunity to collaborate with families as well as districts, and I very often try to succeed in building bridges and not building walls. So with that, I turn it back to Attorney Berliner and Jane, and we'll get on with the questions.
One housekeeping note, all of our contact information is in the chat for Allie, Jane, and myself. If you want to follow up with any of us, our contact information. I just have a couple of quick announcements since our last webinar. Earlier this month, the State Department of Education issued a policy guidance for the vocational technical high school systems here in Connecticut. In the past, these high schools, which are school districts just like your local district, covered by the same federal and state laws as any other school district, seem to self-exempt themselves from the special ed laws. We've passed a series of legislation over the past few years, culminating with this memo that came out earlier this month from the State Department of Education, with respect to making sure that local school districts are sending their records to the vocational technical high school systems. And we have several located throughout the state. Many of them have some very exciting programs, not only traditional trades, but also if you're looking at technology, computer programming, there's a lot of exciting offerings in our vocational technical high school system. So what this memo is trying to do is remove that barrier, making sure there's more collaboration between the school districts and the vocational technical high school systems, and that children or students with disabilities will have the same educational opportunities in a vocational technical high school as if they were attending their local high school. The curriculum is different, the outcome is different, but it's certainly an option worth exploring. The other change or announcement is another policy guidance was issued refining the definition of developmental delay. At one point in time, developmental delay was age 3 to age 5. This policy, based upon a new piece of legislation, extends the age of eligibility for developmental delay through age 8. These publications are available on the State Department of Education website. ct.gov is the state website. The last piece I want to just talk about briefly, for those who have contacted their state senators and state representatives supporting the changes to the definition of an intellectual disability, our state law was revised by the state Senate and the House of Representatives. It's awaiting the governor's signature. So if you are concern about House Bill 557, which is redefining the definition of an intellectual disability, contact the governor's office, as I have, and urge the governor, Lamont, to sign that legislation. So that's a little background information. And we are here to try to answer questions and hopefully, as I said before, empower parents.
Well, we had some questions that came in before the webinar tonight, and it's interesting because myself and Ali are both advocates, and we both come from a background of being involved in education. Myself, I have my master's in early childhood education. I've been a teacher, and I now am the director and oversee other teachers that support students with a plethora of needs, and we develop individual programming for them. Lawrence, however, is an attorney, an extremely experienced attorney across many facets of the special education world. So to both Ali and Lawrence, how do you see the role of an advocate being different to that of a lawyer? What are the values of both that they bring to the table, and at what point should somebody seek the support of a lawyer versus an advocate? Ali, I'll ask you to go first to describe where you see the role of an advocate, and then obviously Lawrence can then take us to the end, which is what attorneys typically do.
Okay, thank you. First of all, I should say that some of the roles do overlap. Okay, an advocate could do many of the things that an attorney can, and vice versa. However, an attorney can certainly do more because of the legal aspect. As an advocate, what I feel I do best is that support that I provide the families in ensuring that their child's needs are met. It doesn't always happen 100% of the time, but we give it our all, and we know how to kind of navigate the system, so to speak, as an advocate, because that's our area of expertise. So we support, the child in getting what his needs. And another role that the advocate does play, and I feel well, I know that Jane and I have a lot of experience with it because we have been in the educational field, is really looking very, very deeply and precisely at that IEP. I can go back and forth with that IEP. I know it by heart, and I know, what to expect and how to work through a lot of the goals and the objectives. So the goals and objectives are measurable, and they also need to be achievable. Many IEPs are not written that way, so that's one area that I really look at very carefully. There's a lot of language in the IEP that may not be user-friendly to many of our families. It's not really done on purpose, but I think that just the nature of the IEP is sometimes difficult to understand. So I really do work with families in training and how to read that IEP, understand it, and how to monitor their students' progress. And I also network with a lot of outside resources, people in the fields, whether they're psychologists, therapists, doctors. Even I work with other attorneys to really look at all avenues of options that need to be in place for the student. So that's just a few areas that I feel an advocate can really support a family. Larry, you can certainly add to that.
I can't add to that because my background is much different. I'm an attorney. I went to law school. Most of my knowledge is after acquired. I wasn't a teacher. I wasn't a school administrator, but I listen. And I listen to psychologists. I listen to teachers. Certainly listen to my clients, the parents, to find out what's going on. Because the facts are very, very important, but I'm a lawyer, so I'm involved with the legal aspects of a free, appropriate public education. Often I leave it to the advocates and others who have the expertise, the experience to get into the details of the language of the IEP. Where I get involved, typically is when the wheels have gone off the track. The parents have advocated, they have private advocates, they have evaluators, all contributing to the development of the IEP, but there's a lack of meaningful progress. And that's one of the component parts of a free, appropriate public education. Free, appropriate public education is the legal equation of what your child is entitled to. Free is without direct cost to the parents. Public and education are typically the school districts. And the word appropriate has never been defined by Congress. So it's not the dictionary definition. Maybe Congress meant that in 1975, but that's not how the Supreme Court has seen that since 1982, when the first special ed decision was issued by the United States Supreme Court. So we look at process. Did you get your procedural safeguards? We look at substance. Is there meaningful educational progress? Does your child know more today than, say, a year ago? Because these IEPs are written for 1 year. We look at, is it a categorical IEP, or is it generic, or is it individualized, targeting the child's unique needs? And that's where the legal experience, the laws come into play, because now I have a matrix to hold that IEP against. Did you get your procedural safeguards? Yes or no? Did you have meaningful input into your child's IEP? Yes or no? Was it individualized? Yes or no? These are sort of a mental or written checklist that I go through in trying to determine what the next steps might be for my clients. And a lot of the spade work is done by the advocates, where they have gone into the details of developing the language of the IEP, but they can't take it any further. And the taking it any further is the point when parents start to review their IDEA procedural safeguards and start looking at alternatives. Alternatives might be, do we need an outside evaluation? Do we need an alternative placement? Do we need more services in the IEP to ensure that free, appropriate public education? So a lot of what I do with the advocates overlaps, but there's a point in time, more or less the litigation piece, where the advocates typically stop what they're doing, and that's often where I'm picking up. But I do go to PPT meetings. I do, listen to, the development of the IEP. But as I said, I'm a lawyer. I'm not an educator. I'm not an administrator. But I do my best to articulate my clients' concerns and advocate for them as well.
I think one of the things that Allie and I and Lawrence are all good at doing too is interpreting and reading the evaluations. They can become very complicated, and parents can be very overwhelmed by the data that's provided. But for Allie and I and Lawrence, that data is the key. And we use that data to solicit and ask for maybe additional evaluations, maybe additional services. We use that data to review, revise, and edit existing goals and objectives, and to make determinations as to whether your child has made meaningful progress or not. So I do recognize that when you are receiving a report from a school district that might be 18 plus pages long, and then you're receiving multiple reports simultaneously, it can be extremely overwhelming to decipher that information. It can also be very disheartening. And there's a value to having an advocate or an attorney in the room, as we are able to be that little bit more objective. It's not that we don't care, but we don't have that personal relationship with a child that as is being discussed, and we're able to extrapolate that data, review it, and have a conversation with the team around the table, because maybe not all the practitioners around that table understand the content of the data presented by the different clinicians or related service providers either. So sometimes we're able to help connect the dots between the different related service providers, whether it's an SLP, an OT, a PT, or a BC, ABA, or school psychologist, or other individual, because they might just be very focused on their specialist discipline and not understand the correlation that the interdisciplinary activities can have with each other. And I think that's the other value that having an advocate or an attorney such as Lawrence can have. We're able to connect some of those dots. But Allie and Lawrence, we had the question, which we typically get, What do you recommend that parents do when services are denied, even though the parents feel that the data represents the fact that the student does need additional support or review or revision or edit of the IEP and the goals and objectives within it?
So I'll just begin by saying data drives instruction. If what you're saying is that you have the data, that means the evidence, but you may not have sufficient data or the most appropriate data. So you may need targeted evaluations to really zoom in on the area of a challenge that your child is having. And those evaluations can really help support the data that you already have, but also add new information. Um, you know, it's very logical that schools try not to give all of their services because it usually adds up to time and financial, obligations for them. So, as an advocate, and I'm sure as an attorney, Larry, you would support and use that data to advocate for the services. If it gets denied, then you have your parental safeguards, your rights, and that's where the mediations come in or the due process comes in.
And just to add to that, also a right to an independent educational evaluation that's paid for by the school district, that if you disagree with the school district's evaluations, you can request a publicly funded independent evaluation because the data comes from multiple sources, not a single source. It's not just the school district's data. Parents are an important source of information. And sometimes we need an outside, fresh set of eyes, fresh perspective to look at all existing information, observe the child in some cases, doing standardized assessments. And if the private evaluator, say a psychologist or a physical therapist, occupational therapist, wherever you're going for the independent evaluation, comes up with similar outcomes, and probably the IEP is okay. But if the private evaluator cannot replicate the data that's being presented by the school and other sources, then often they will come up with a series of recommendations to revise the IEP, add certain methodology, remove certain things, change a primary disability. That happened to me last week. The school was ready to gloss over the private evaluator's recommendations for changing the primary disability until we brought it up. And that primary disability was very significant in driving development of the IEP because the existing IEP didn't cover what the new evaluator had found in the report. So it's important, and as I said, parents are an important source of information. I respect my client's opinion. They don't, they see their child in multiple settings, as I mentioned before. If a child's learned something in school, they should be able to generalize it to home, community, other settings. And when that's not happening, that's where we have to start figuring out, what's going on. Is it meaningful or not? Is it accurate or not?
And along a similar line, this was an interesting question that we had presented before this webinar, along similar lines of valuations, but this one's a bit more specific. So somebody's asking, can they have their child reassessed for physical therapy if the evaluation was conducted with their son wearing braces? Now, the same could be true of a child having access to something that enables them to ambulate or navigate the school setting. So what would be your recommendation of having a child, in this case, evaluated while wearing braces versus being evaluated while not wearing braces or having access to the piece of equipment that can help them ambulate, for example?
You want the most up-to-date information. We use phrases like triennial evaluations, where the school districts are obligated to evaluate a child's actual or suspected disabilities every 3 years. But if there's been a change of circumstances during that 3-year period of time, there's nothing preventing a school district from completing their own updated evaluation. So if the child was wearing braces at one point and there's a change of circumstances, the child is no longer using braces or required to use braces, then we need to update the IEP. How are we going to update the IEP? Certainly parent input, but possibly another evaluation. Now, that's where the disagreement could come into play. If the school district says, no, you're not due for an evaluation for another 2 years, we just did the triennial last year. That's where a parent could end up disagreeing with the school district's evaluation and requesting an independent, publicly funded independent evaluation. So there's not one answer to the question. It's always advisable to try to collaborate with the school district, try to avoid the confrontation whenever possible. But parents have rights. Those are the IDEA procedural safeguards, and all of them are important.
I would imagine in a situation like this, that the student's IEP in physical therapy is no longer accurate, because the circumstances have changed. So therefore, the goals and objectives under physical therapy have to be revised. And the only way they can be revised is through an evaluation process. And there are many ways to evaluate. It doesn't always have to be standardized, but that's certainly one way. But there are also informal, avenues to take, observations, and so forth. So it really looks, this is a situation that the IEP is really not serving the child appropriately and accurately.
Yeah, along a similar line in terms of just assessments. So we had a question again, how do schools assess behavioral needs versus academic needs and make sure that a distinct plan is developed for the academic and then a plan for the behavioral, but also there might be cross-pollination between the two. A child might need supportive services regarding their behavior and access to a curriculum in order for them to maintain academic progress that's meaningful. So how do you suggest a school assess behavioural needs and academic needs? In this instance, the parents is looking to have it done separately.
Do you want me to begin?
Yeah,
Okay.
Please.
When it comes to behavioral needs and academic needs, often one impacts another. Behavior impacts academics and vice versa. Academics impacts behavior. So the two evaluations do need to be integrated at some time. In fact, all evaluations should be integrated because you need to look at the child as a whole. But that being said, there are evaluation tools that are specific to behaviors, and there are evaluation tools that are specific to academic achievement. I'm not going to go over, each name of, the evaluations or the assessments used, but behaviorally, there are rating scales, there are structured observations. There's a process called a functional behavioral analysis, often termed as an FBA. If you hear that anachronism, it's a functional behavioral analysis. And that is a series of structured observations that target certain behaviors over a period of time in different and various settings within the school environment. So that is a behavioral tool that is used very effectively. Academics, there are many academic, evaluation assessments depending upon your child's needs, whether it is focused on literacy, math, executive functioning. There are, a myriad of different evaluations, but the two can be and should be separated. But again, at the end, I think it also needs to be combined to really look at, okay, how does behavior impact achievement and how does achievement impact his or her behavior?
So we got a question as well, which is, we just got this in this evening. So this is often, I'm sure, Allie and Lawrence, you find that families come to you when they feel that the relationship or the communication between themselves and the school has deteriorated, or they're not being heard in some capacity. And so the question was, from the parent's perspective, how do they get the courage to speak up without feeling like the relationship will change between the school faculty and the family? I know that with my experience is you just remain calm, you remain professional, and you focus on the data and you focus upon the information at hand. You do not make this a personal situation. You prioritize the needs of the child and the individual needs of the child. And you build collaboration and partnership and open, honest communication, but you keep it very professional. And I said about the data, the information, the child. Allie and Lawrence, what other recommendations do you have for families to have the courage to engage in something when maybe they might feel it might become confrontational and they want to make sure that the next few years in the school are collaborative?
Well, there's no one answer. I mean, parents, from my perspective, are the best advocate for their child. And if they're not there every single day, who is? You know, I can be retained, Jane, Allie can be retained, but on a day-to-day basis, parents need to understand the system. They may understand their child's needs, but you're dealing with a system. Some school districts are collaborative, some are not. That's unfortunate. I think all should be collaborative. It should not be a confrontational experience. I'm right, you're wrong. That gets us nowhere. And information, for example, work samples. Parents often will get work samples that demonstrate a lack of progress. You know, the spelling is off, the handwriting's atrocious, the math calculations are wrong operations. Whatever information parents bring to the table, it's very, very important. When parents, there are training opportunities out there. The Connecticut Parent Advocacy Center is one source of information. This webinar that Jane and I have been doing for 6 years now, and we don't have a monopoly on webinars. There are many opportunities out there. Parent support groups in communities, the parent networking within a community where information is being exchanged. There was one town, they had I think it was the Wednesday afternoon pizza moms or something like that. And they would get together and collaborate, probably at a pizza restaurant. That's probably why they call themselves the pizza moms. So there's many, many ways to handle this. But if you feel you're being disrespected, if you feel you're being intimidated, Connecticut Family Support Network, another resource. I'm sorry, I'm getting I sign off camera. The Connecticut Family Support Network, another very important source of information. But if you're feeling you're being disrespected, if you feel that you're not being heard, often that's where advocates and attorneys and others get involved. One of my favorite stories is I had a parent that said, how come when I ask for something, the answer is no? But when you go to the PPT meeting and ask for the same thing, the answer is yes. I said, obviously they hear better when there's a lawyer in the room. I don't know what changes the school district's decision. I mean, I presented the same information, the same requests, but two different outcomes. And there's that old adage, you can't fight City Hall, but yes, you can. You can fight City Hall. And it's very important that parents understand their rights, their role. The federal law talks about parents providing their input and concerns for enhancing their child's education. And that should be the beginning of every PPT meeting. These are our concerns. We like what you're doing, but this is what could happen to make it even better. And work samples, other sources of information, pediatrician recommendations, there are all kinds of information out there, but parents should be empowered, not intimidated when they're dealing with a school district. It's not supposed to be an us versus them situation. Sometimes it is, most of the time it's not. It's supposed to be about us. And most important, it's about the child, the student. And sometimes the student's needs get lost in the process, and that shouldn't happen.
I just wanted to share just a few of my strategies to build collaboration. I'll be very brief. You mentioned, Larry, to share parents' concerns, and I do encourage every parent right at the beginning of the PPT to make a statement. And I always suggest to them, let's start off with something positive. And I think that's really kind of sets the groundwork, the framework of the PPT. You may have to dig deep in your pockets to figure out what is positive, but usually you can find some positive way to compliment the teaching staff. And then you go on to your concerns. Another strategy that I use fairly effectively is open questioning. I rather than telling the staff what I feel needs to be done, I will ask a question such as, "Oh, Johnny scored below grade level in this. What are your suggestions to improve his reading?" Let's say. That's just off the top of my head, okay? Rather than me telling them what I think I know would be the way to help improve, I ask them. And this empowers the teachers. They feel empowered. And I think that is very important for the teachers to feel that so they have, more input into the IEP. Lastly, our team meetings. I highly suggest informal team meetings periodically, and the duration and timeline is certainly, up to you and the team. But these team meetings really do help build collaboration because they're not formal. There's no legal framework involved, and you can talk freely but productively. And I think that's certainly a way to build that collaboration.
Yeah, and I've attended team meetings and used it as a brainstorming opportunity. I am lucky that I'm familiar with lots of resources out there, whether they're therapeutic or otherwise. So sometimes I go along to those and we literally brainstorm together, which can be really valuable time well spent when you actually can take yourself outside of a PPT meeting with individual team members and specialists. So as Ali said, that's also a very good opportunity. And we had a question in this evening, how can a parent hire a lawyer? There's lots of different websites that you can engage in to look for different lawyers. Obviously, we have our own website. So you can engage and find lawyers through different platforms. You can also, if you are a non-English speaker, you do have the right to have a translator at any PPT meeting and any conversation you hold with a school district. Some of our districts have students with over 92 different languages spoken in their educational system. And it is your legal right to have representation and to have somebody there to translate the meeting for you. The modes of communication and translation are not always ideal. Sometimes you dial a translator in and it can be cumbersome and it can make the meetings last longer and things can be lost in translation. But it is always your right to ask for and to request for there to be a translator present. It is so important that you as the parent always understand and are able to communicate directly with the district. Do you have anything else to add with regard to that, Lawrence?
Just one additional thing. The State Department of Education offers the documents to be translated. I don't know what the number is, but multiple languages. So it's not just English, Spanish, but many other languages. I think it's through the CTSEDS, the computer system. I don't know what, it's probably a half a dozen, maybe a dozen languages. It's not 92, I know that, but they are working on it. And so that's another source of information. The translator is required, a qualified translator, I should say, not an unqualified, or having a family member translating. The school districts are required to provide that kind of service as part of the federal special ed laws.
I do acknowledge that it can be expensive to hire attorneys and advocates. There are some organisations out there that will provide free pro bono support and representation. And there are also different organisations that you could submit applications for to receive a certain amount of funding to pay for a certain number of hours for an advocate and attorney. So I do acknowledge that it's not an even playing field, but I just recommend that you explore the resources that are out there if you are looking for somebody else to support you through the process and to navigate it next to you. And another question we got as well as before that families ask, can they reject a placement recommendation and request another placement that has been suggested by a school district?
Well, it all comes back to the data, and it all comes back to that free, appropriate public education. If your child is, sometimes we're disagreeing over the rate of progress, but the progress is there. And sometimes the progress is trivial, which is a denial of a free, appropriate public education. Or worse, there's regression, which is certainly a denial of a free, appropriate public education. What I do on behalf of my clients is I look at the records. I try to identify trends in the records, an apples to apples comparison over time. Are we seeing the arrows trending up, sideways, or worse, going down? And sometimes we need to have an outside evaluator, a psychologist, a reading specialist, physical therapist, occupational therapist, to prepare a report with recommendations for a change in the IEP, or in some cases, if you can't implement my recommendations, then I am recommending an alternate placement. So working with the outside evaluators is very important. Trying to collaborate and make sure you're on the same page. I've had people say the only time you get involved is to get an out-of-district placement. I said, surprisingly, many of my clients want in-district placements, but they want that to be appropriate. They want to be with the neighborhood children, the siblings, the cousins. We moved to this community because of these schools, parks, beaches, whatever causes parents to move to a particular locale. And they would like to see a payback on their investment of time, energy, and money in the community. And that's what in special ed, that's that free, appropriate public education where you see progress, where the child is being prepared for each next step of their life, preschool to elementary school to middle school, high school to life after high school, and having a solid down payment on each next step. So we all can celebrate progress rather than seeing what I had a client once say, do you ever have happy clients? I said, they are happy often after I'm involved, but not prior. Why would they want to contact an attorney if they were satisfied with the school district? Sometimes parents want a reality check and see if their instincts and wisdom is spot on, or are they asking for too much? Sometimes I don't think there's ever too much, but some of my clients feel they're asking for too much. Free appropriate public education is a floor. It's not a ceiling. You can't fall below a certain level, but there's no cap on what is a free appropriate public education. Unfortunately, it varies from school district to school district because the resources are not spread out evenly throughout Connecticut, and in some towns are not even spread out evenly from neighborhood to neighborhood.
Yeah, and talking about transitions, and this is the time of year where students we know are going from one grade progressing up to the next grade. And so, Allie, we had a question that came in. What do you think are the most important transition items to cover for an 8th grade student that's going to be going to high school, and in this instance with a reading disability or an autism diagnosis? What would your recommendations be in those situations?
Well, transitions are very important, whether it's preschool to kindergarten or elementary to middle school to high school versus post-secondary. So I'm going to try to zoom in on the middle school to high school because that was the question. First of all, most districts have what they call transition PPTs. In other words, a PPT towards the end of the year. I'd say around now. It could be a little earlier, starting in April through mid to end of May, where they would invite the high school, some of the high school staff, certainly not every one of the team, but key people at the high school to be participants at this PPT. And at that PPT, you discuss the needs of the student. So if the need is in reading and I believe it was ASD, then you would ask those questions. And I would certainly suggest that you have a list of questions to ask ready before that PPT so you're well prepared and you can read off your list. Questions that I would ask would be what program or programs do the high school follow for literacy? Who teaches it? What is the experience of the teacher that implements instruction? How long are the class periods? Where and when do the students receive this instruction? Sometimes it's in a resource or what they call learning labs. Sometimes it's also part of the general ed classroom. They push in. Whatever, those questions need to be formulated probably before the PPT so you have those ready. My suggestion would be, again, to do a lot of this work outside of the PPT. A transition plan needs to be very detailed, step by step. In other words, who's going to do what activity, when it's going to be performed, and who will be responsible for implementing that activity. So it's who, when, what, where. That transition plan also needs to include the student. Will the student be visiting the high school? Will the student be visiting key people, a meet and greet kind of a situation at the high school? Will the high school, if it's a student with significant ASD, they may need to come down to the middle school and observe the student in his or her environment. So there's a lot of steps to that transition plan, but I think, again, that work can be done outside of that PPT without any decisions made until the PPT and then reviewed for acceptance. But I do think that a transition plan needs to be visual and very concrete and very specific.
We had a rather complex question come in this evening, and it's very hard to answer every part, but this is the takeaway. If your child has a 504 plan, which is a plan of accommodations, typically without any direct instruction, and you think they need direct instruction in the form of an IEP, you request a referral to special education, a PPT meeting, and an evaluation in order to determine eligibility. And another piece of the question that came in was discipline. Unless a child has been in an in-school or an out-of-school suspension situation totaling 10 days, there's not a lot that can be done to challenge a suspension. When we get to that 10th day, there are rights. There are rights under the United States Supreme Court decision. If your child has a 504 plan, there are rights under that federal law. And if your child has an IEP, there are rights under the federal special education law. And that involves what's called a manifestation determination PPT meeting. School districts can suspend a child for up to 10 days, but once we have in a school year, but once we have that 10th day, that's where the rights under the federal Supreme Court, federal law 504, the Supreme Court decision, and the federal special education. So if your child doesn't have an IEP, ask for an immediate referral to special education, a PPT meeting, a request for an evaluation, share any data that you have, maybe have a letter from a pediatrician or an outside evaluation report. It's very important not to delay, because where we are in this part of the school year, if the referral comes in before the end of the school year, they have to process it. But if it comes in after the school year, they can wait until the next school year before processing a referral.
Another question that we were given beforehand too is how do we calculate compensatory services? So it's the end of the school year. You believe your child has not been provided all the related services that the IEP had calculated and detailed. So what do families do to calculate any compensatory services at this point in the school year, Larry and Ali?
Well, we start with the IEP. What does the IEP call for? Is it an hour per week, of services? And if those hour per week of services are not being provided, you multiply that out by the number of weeks that the service was not provided. I had a case many years ago. The student was supposed to have 21 hours of special education with a special ed teacher per week. The school never hired that teacher. So we looked at the IEP as written was not being delivered. We eventually filed a complaint with the State Department of Education, and they ordered compensatory services, making up the lost hours. You can't make up the lost educational opportunities. And by the time the state finished their investigation, several 200, 300, 400 hours of instructional time was owed to that student. So sometimes it's an hour for hour makeup for the lost time. Sometimes it's more equitable. We come up with as I said, we can't make up for the lost educational opportunities, but maybe we can come up with a collaborative way moving forward to come up with maybe a summer program or an after-school program or some other way to make up for the lost time and the lost educational opportunity. So sometimes it's an hour for hour, minute for minute makeup. Sometimes it's another way of calculating compensatory services.
Ali, I know that you had some things for parents to look out for when it comes to compensatory education. Do you want to just discuss that on this platform right now too? Because you have some good points to share.
Yeah, sure. It's come to my attention that some PPTs that districts have offered compensatory services, whether it's due to teacher absences, teachers and not being having the accreditation that the IEP states that they have for various reasons. But the important thing to remember here is that you don't want your child to miss learning, to miss time within the classroom or any related service. So oftentimes I hear districts saying, okay, we agree to compensatory education and we will service your child X amount of hours during the school day. And then my question is, well, what will they be missing during that school day? And oftentimes, and most of the time, they're missing something that is valuable. Even recess, lunchtime, whatever it is, there's no wasted time in school, or there shouldn't be wasted time in school. Peer community relationships are very worthwhile. So if it's recess, that is something that should not be dismissed. So then we talk about when the compensatory services can be applied. And, as Larry said, we can become creative. We can look at summertime. We can look at possible weekends. We can look at vacations, extended school day. Of course, if your child has ADHD, maybe that's not the optimal time to have an extended school day. But, each student is individual. So you have to do what, is most appropriate for your child. But again, just kind of be alert to the fact that you don't want your child be taken out of another school-related activity during that school day. And therefore, it's no longer compensatory because they are missing something else that is desperately needed within the school day.
And compensatory services don't always have to be provided by school practitioners or service-related providers. For example, if you have a relationship with a speech pathologist, that speech pathologist that already has a relationship with your child could be the one that administers those additional hours of service at the expense of the district, so that you are not out of pocket for those services provided by a private practitioner. So there's lots of different ways. As Ali said, this is when you can be creative, and going into the summertime, when we have, more opportunities to maybe potentially provide your child with additional support and services, this might be a time to look to calculate what is missing and offer it during that time in consultation with your school district.
We had a question come in about independent evaluations, a multi-part. My short answer is the State Department of Education, which is available ct.gov, that's our state website here in Connecticut, has a publication, a guide to independent evaluations and in-school observations. Half of the document is independent evaluations, the other half in-school observations. It's a very detailed publication, and it'll answer a lot of questions of parents who are not sure they want an independent evaluation, decide that they want an independent evaluation, don't know exactly how to request one, or what happens when the school district denies the request for an independent evaluation. So I would strongly urge that parent and others who look at the guide to independent evaluations and in-school observation. It is available on the State Department of Education website, and it should answer questions how to get the independent evaluation and dealing with pushback from a school district when it's denied.
We also had another question where they were asking if a school district denies an IEP, but you still believe that your child requires services. I think this goes back to what we've been saying, that it's the data should drive the delivery of the service or the denial of that service. Any suggestions or recommendations, Ali, what families should do if a school district decides to stop providing an IEP or a 504?
If the school district decides to stop an IEP or a 504, they need to evidence the fact that the child is no longer needs those services or accommodations. The way that they would evidence that is through an evaluation. Data alone, most parents are aware through the IEP that you get your progress reports either quarterly or trimester. And those are those data sheets that say S for satisfactory, M for mastery, U for unsatisfactory. Well, those are indicators of your child's acquisition of their goals and objectives. But that is not the only data point that should be recognized. Evaluation is necessary to determine whether the child continues to need services or not. If the services are denied after an evaluation, then it would be the parent's option to either ask for an IEE, as Larry suggested, or to do their own private evaluation through a specialist, an outside provider that could or may differ with the school's in-house evaluation. And if it continues to be denied, then again, you have your due process rights.
And the evaluations have to be all area of a child's actual or suspected disabilities. I often have parents say, well, my child has a disability. Doesn't that qualify for an IEP? The answer is no, because there are other component parts. You have to have one of 14 categories of a disability recognized here in Connecticut. Some states have more or less, but we have 14. The other piece is you need direct instruction, and that's the component parts of starting to develop the IEP, a disability behind grade level expectations can benefit from direct instruction. That goes into the development of an IEP. The flip side of the same coin is if the child no longer needs an IEP, we have data that supports the school district's decision. So it's not just the flip of a coin, heads you're eligible, tails you're not. It's very data driven. And as Allie pointed out, independent evaluations, private evaluations, other sources of information is the way to go, because parents, as I mentioned several times, have a lot of wisdom, a lot of instinct, a lot of experience seeing their child in multiple settings. And what I tell my clients, if it doesn't feel right, don't talk yourself out of that feeling. If you have that little voice in the back of your head that's telling you this isn't right, don't silence that voice. Act on it and validate it, and see where that is leading. Sometimes sometimes parents are told, you're too involved. What do we have? Helicopter parents, snowplow parents, all these negative. Parents are parents, and we're hardwired to protect our children. We're hardwired. That's what happens when we're parents. And respect is a two-way street. Schools should respect parents. Parents should respect schools, and hopefully we can all get along. But again, as we all have said many times, when the wheels go off the track, you have your IDEA procedural safeguards.
I just recommend as well, just ask questions. Like Larry said, go by your gut instinct. Don't allow a situation to manifest and become much larger than it might need to. You can nip some situations in the bud quite easily by asking those direct questions. If you're not, and if you do ask a question, it's also sometimes helpful to follow up with either verbally or in writing as well, so that you have communication line to show that you did ask a question, that you did raise a concern, and there's a timeline that is time stamped for that. And the other thing I would recommend, more and more we enter into the realm of AI and chat, and I do, for example, get a number of families that use chat. And chat has its virtues, but it also has its pitfalls. And sometimes it does lead families astray with incorrect information. So I think you have to be very careful about the sources that you go to seek advice and guidance from as well. And there are some really valuable sources within the state that you can contact. I know that Larry can mention a few of those, but I just go by your gut, but then ask those questions. Don't sit on it. It should be an open channel of communication. And maybe the school are feeling a similar thing, but are uncertain whether to ask you the questions. I think open channels of communication are the best way forward. But I would ask a question directly with the school versus going to chat to ask those questions first. Lawrence and Allie, do you have any suggestion with regard to that?
No, I was going to just give some additional feedback on the question about discharging a student from services or the IEP. I think I hear very often from staff, from teaching staff, that, oh, well, we're going to dismiss OT, or we're going to dismiss the goals in math, whatever. And the reason they give is, oh, well, they mastered all these goals. Then when you look at the goals, you have to really read between the lines. Did he master or she master the goals independently or with support? Are the goals finite, or does the student need more goals in that area? Are the goals generalized? That's another question. In other words, many of these services, like in speech, are given within the service area, the speech and language resource area. But is the student able to perform these speech and language skills outside of that very structured setting? So again, I think it's about understanding how to read the IEP, knowing the questions to ask, and being very vigilant about what the teachers are saying in regards to your child's acquisition of skills versus their readiness to be discharged from those services or a full IEP.
We had a quick question about when to start formal documentation. Right now, today, and I advise my clients always to put things in writing, whether it's an email or a note, because I don't ever dispute that a conversation took place or a meeting took place, but if there's no record of that conversation or meeting, then send an email confirming a conversation, thanking somebody for their time discussing my child's issues. Or, just sending an email, my child's not reading, what are we going to, can we meet so we can discuss what we're doing? And this way you're building that written record. And that's important. So the person asks, when do you start formal documentation? Today. And that way you're building that record. And then we had a very quick question on an evaluation for a child in reading, writing, and math, but the school district did a triennial without completing writing and math. If the school district had the opportunity to evaluate in all three areas, then elected not to, then you have that right to an independent evaluation, a publicly funded independent evaluation. If it was done by agreement that we were only focusing on reading, there's no more issues with math or writing, then you could ask the school district in that case to complete an evaluation. There are what are called OSEP, which stands for Office of Special Education Programs, policy guidance memos. Unfortunately, the United States Department of Education is trying to put itself out of business. So it's not exactly certain where all of these OSEP, Office of Special Education Programs, policy guidance, some of them are available on the internet, some are available on the US Department of Education website, some of them just happen chance, you're just dialing around the internet and you come across an OSEP memo. And one of them talks about a parent's right to an independent evaluation when a school district had the opportunity to evaluate a child's suspected actual or suspected disabilities, but elected not to. So it's important, as Jane pointed out, the source of information is very, very important. 2 weeks ago, I attended a continuing legal education seminar, and the last hour was on artificial intelligence. And I can just say it was frightening for me to listen to these experts on artificial intelligence and basically telling us how much we don't know about artificial intelligence and how it can lead us astray with misinformation. It's designed to generate an answer. Doesn't mean the answer is accurate. So be careful. Go to your trusted sources for information. When I will pose a question on Google, it'll take me to artificial intelligence. I go to the next one below that to start seeing what the state law is or what a government agency is saying, not what artificial intelligence. So you have to go to trusted sources.
And I just want to quickly remind parents too that in the state of Connecticut, when you are in a PPT meeting, you can ask to record that meeting, and the school district will also record that meeting. And I do know that for some people during those meetings, you become very overwhelmed and you forget what was actually said and the devil in the detail of what you agreed and what you didn't agree. So don't forget as well that it can also be helpful to ask to record a PPT meeting so that after the fact you can go back, you can re-listen, you can review it. Or if there's another family member that wasn't able to attend or another practitioner that you work with that wasn't able to attend, you could share elements of that conversation or the meeting with them. So that is another important source of information and a data point that you can use when you transcribe it at a later date as well. But that also can be helpful for recording accurately what was agreed or not agreed during that meeting.
And I'll just add to that, if the school district records the PPT meeting, that's an educational record, just like an IEP is an educational record. We've come to our end of tonight's webinar. We want to thank everybody who is still here and those that might see us on YouTube and other sources where these webinars are posted. So I want to thank everybody for joining us this evening, for your continued positive response. We got a lot of very interesting positive feedback, and we very much appreciate that, Jane and I. If you found this evening's conversation informative, we welcome your continued participation down the road. We have a YouTube channel for the Law Office of Lawrence Berliner for previous webinar recordings. I want to thank Allie Grafman, who has given many hours of services to these webinars, and we appreciate her perspective, her experience, and wisdom in helping navigate these difficult times. Also to Jane Faherty for her collaboration, insight, thoughts, and very practical advice. I also want to thank my daughter, Rachel, who's off camera to my immediate right, because without her, these webinars could not take place. She puts it all together. She's your point of contact. And I know I very much not only appreciate her being my daughter, but being my tech person as well for these webinars. We welcome your questions, and down the road, we hope to have webinars next year, and so just keep checking in. You'll get announcements from Rachel, my daughter, when we have webinars, the Berliner Special Education Law Facebook page, my website, Instagram, the JCC website, and Facebook are all sources of information about these webinars. So I want to very much thank Jane for another successful year of doing these webinars, and Allie, very much our special thanks for returning to
My pleasure. Thank you.
webinars. So have a safe summer. We'll contact you about next year. And Jane and Allie, any concluding remarks? This is your opportunity.
Just to say, it's been a fantastic to share and collaborate with you again, Lawrence, this past year. It's gone extremely quickly, and none of this would be possible without Rachel and also your wife Debbie's participation and support and expertise. Whether it's coming up with the ideas or connecting us with the community partners to share their knowledge and expertise. There was a quick question in here relating to us providing this in different languages. Regrettably, Lawrence and I are not fluent in any other languages. This is where I do suggest that technology might be able to help to translate what we're saying. So apologies that we are not able ourselves to communicate in different languages. I can do a little bit of French, but that's about as far as it goes. So, but technology might be able to help. But again, Ali, it's been wonderful to share this conversation with you. And I look forward to having more conversations with you next year. And in the meantime, if families do want any support, you are welcome to reach out to myself, Ali, or Lawrence to help you further at a later date. So good luck, everybody, and I hope the end of the year ends well for you and that you also get to relax and enjoy some of the nicer weather ahead of us. Ali?
Just a quick thank you. It's my privilege to be part of this panel. It really helps me to stay focused, and I also appreciate the audience participating tonight because I know what the end of the year brings and how complex and busy it is. So kudos to the audience. Again, Rachel and Deb, thank you. It wouldn't have been possible without you. And I look forward again to next year. Have a great summer, everybody.
Thank you very much. Good night.
Good night.